just use a deed or a titling document to avoid probate.
Yeah. So the shortcut may well not work.
Right.
And the problem is that people are trying to avoid attorneys. I hate to
Right.
say it, but anyway, they are.
Well,
they're afraid of the fees, what
right.
have you.
There's a reason people want to avoid that.
And maybe they're concerned about privacy, I don't know. But the fact of the matter is, I call it self-administering, you know.
Right.
And they do it related to probate too. I mean, they don't do probate when they should, maybe,
Right.
or even administer a trust properly, because they're not looking for the help that they should get. And so there's the old thing about, was it penny wise and pound foolish, that they're actually in many cases making mistakes and costing their families maybe some heartache in the process.
Mm-hmm.
Okay, well, what are some concerns about holding property as joint tenants with children? So you've already talked a little bit. Maybe you go in the
Right.
wrong order, and that's
no. There are other concerns that we didn't talk about that can be really significant, because it isn't just people don't necessarily die in the right order. It's that when you put people on title to your property, it carries with it a lot of things that people haven't necessarily considered, but can become major problems.
Yeah.
So if you own your home and you add your children as joint tenants, and then they go through a divorce, or they die and there's a probate, or there's an automobile accident and the liability exposure exceeds the insurance coverage, or they have no insurance coverage, because they have their name on title to your asset, it's also an asset of their estate, or an asset for creditors' purposes. So that's a very significant problem that people don't necessarily consider. Another problem, and I've had this happen, is where the parents will add the children to title, or other people to title. For whatever reason, they're going to try to leave them the property, you know, through joint tenancy or something like that, and then they have a disagreement and a falling out, and no longer want to do that, and you can't get cooperation from the people you added to title to just voluntarily leave title.
Right.
And I've even had court cases over that.
Yes.
So it sounds like a good idea, but it's one of those things that if it goes wrong, it can go very badly wrong.
Yeah. Well, one thing is, I've seen this in some cases where the people continue to think of themselves as the family, and it's almost like the family with the little kids, but they've got adult children. And once they become adults, there are other issues that
Right.
that become involved. And so when they, well, even when they're little kids along the way, of course, that needs to be provided because they can't really manage the property themselves. And when they become adults, they need to also be provided in an orderly sort of a way to try to reduce the conflicts and so forth. And I think another thing that we talked about before is that people don't think that they're making a gift necessarily when they're putting a person's name on title as a joint tenant.
Right.
But as far as the IRS is concerned, and the federal tax laws, that's exactly what you've done.
Well, it actually can work. You know, you can be whipsawed by something like that, because on one hand, you can be deemed to have had made a gift. On the other hand, if they're looking to calculate how large a person's estate is, they oftentimes will sort of disregard the joint tenancy things and look to see what the contribution was for things like bank accounts.
Yeah, they do tracing.
Yeah, so
but technically, I think you're supposed to file a gift tax return.
you can get hit both ways.
Yeah.
You're right. You know, and you know, it should only be one way or the other. But again, these are unintended consequences, I think.
Yeah, and there is some fuzziness in our tax laws. All right. How can a husband or wife accidentally transmute or change separate property to community property, and what are some of the consequences?
Well, you need to talk a minute about separate property versus community property. Community property is essentially, if you're married, it's property that you acquire during the course of a marriage. Separate property, when you're married, is property that either you had before the marriage or that you were received by gift or by bequest or something during the course of your marriage. So property that you inherit, even if you're married, doesn't immediately become community property.
Right.
But it's very easy to turn it into community property if it's money, for example, and you commingle it with other funds in a bank account that is a community account. It's immediately community property. With real estate, it's a little harder to do, but it can happen over time because people do things like they'll inherit a house, but they'll use community funds to put the new roof on or to maintain it in some way or pay the mortgage, and it becomes community property that way. The real problem is several problems with this. One is that people don't necessarily understand how this works very well, so they don't really understand what they are doing, or not necessarily intentionally doing, what's happening. And then the other thing is when people do later pass away or get divorced, that's when these things matter, when they're divorcing or somebody dies, you have to try to sort this out, and it can be very complicated, and that can be very expensive and complicated to try to sort out what happened with the community property versus separate property.
Yeah. So you're creating a mess for the people.
Right, but I think it's important to add to that a married couple can at any point in time agree on the status of their property. Excuse me, they need to do it in writing, and they probably need to have separate legal counsel if they're going to do that. But they have that ability, and it should be in writing, to actually clear it up at some point if they want to do that.
Right. All right. What is a tax basis concern? So again, tax basis means the cost that you use for property when you sell it on your income tax return. It also can be what you use as for when you're figuring depreciation for real estate.
Right.
So how is that affected by whether the property is community property as opposed to joint tenancy property for a husband and a wife?
Yeah, again, this is primarily an estate tax kind of an issue because we're talking about, well, it's stepped up basis, but that happens because of estate issues, not estate tax issues, but estate issues. So when a person dies, if they're married and they hold title to property with a spouse as joint tenants, then the way the tax law looks at that is that the property that was passing to the surviving spouse wasn't passing through the estate of the deceased spouse, it was passing by right of survivorship.
Right.
And so the way that's treated, and there's tax codes specifically on these points, it's treated as the property that belonged to the spouse that died gets a new basis, which is the fair market value of that one half, let's say, at date of death. But the surviving spouse's half doesn't get an increase in basis. On the other hand, if the same property is titled in community property status, then it is treated as passing through the estate of the deceased spouse, and now both the husband and the wife's halves get a new basis at the first death, which is very significant because obviously, well, real estate values aren't as high as they used to be, but they still are higher from people who've owned property for a long time.
Right.
And we know that there are some exclusions from income taxes for people, but after you've lost your spouse, your exclusion is only $250,000, not $500,000. So with a new basis at date of death, bringing the property up to its full fair market value at the date of the first death, you're able to, if you sell the property after that, to not include gain up to that full basis plus the additional $250,000. So there's a significant income tax benefit. Having said all of that, we're going to, in a few days, enter into 2010, and all those rules change. That's a very complicated subject, which you may be able to talk about in a lot of detail, but basically the stepped-up basis goes away as of January 1st. Most people think it will eventually come back in some form, but unfortunately Congress hasn't acted on the estate tax rules, and we don't know what's going to happen.
Right. So just briefly for our audience, what's happened is the estate tax has been repealed for 1 year for 2010. This is something that everybody said couldn't happen, and right now it will happen. However, Congress has the option of retroactively reinstating the estate tax. So they've put a lot of confusion into the estate planning community. Again, this is only going to happen for 1 year, and then in 2011, let's just say the estate tax will be returned with a vengeance, because we're going to have a much smaller exemption equivalent, only $1 million, and the estate tax rates are going to be going up substantially.
Yeah, and all this also affects these basis rules that we're talking about.
And the other thing is the basis rules. So the step up in basis is going to go away, sort of. There will be an election that's available to increase the basis of a decedent's property by an additional up to $1.3 million, and then for a spouse you get an additional $3 million.
Yeah, I think it's one